Our third speaker then, and I think we're on track for questions, is Rosslyn Mckenna, who many of you know. Rosalind is coordinator of Amnesty International Ireland's Human Rights in Ireland project, which is looking at justiciable ESC rights. Rosalind previously worked in the UK Parliament for the Scottish Court Service, as well as coordinating Amnesty's earlier human rights-based approaches work. She's also author of Healthcare Guaranteed and is working on Amnesty's recent work on looking at legislative basis for universal and equal access to healthcare. And she's going to address highest attainable standard of physical and mental health and what's needed to underpin that. Rosalind.
I hadn't realised this was going to be an obstacle course for speakers over the course of the day. That's great. Thank you very much, and I will try and keep this brief so we can get to questions. I'll preface it first with the focus is going to be generally on the right to health and a focus on Amnesty's work on equal access to healthcare, but also on mental health. But I'd say touch base with the relative teams in Amnesty about more of the detail of the campaigns. As most of you will be familiar with, what's established in the Convention on Economic, Social and Cultural Rights is the right to the highest attainable standard of physical and mental health, not as some previously in the Department of Health would have it, that it is that you can sue the courts as soon as you get sick, or sue the government through the courts as soon as you get sick. But it is notable that there's no provision for the right to health currently in the Irish Constitution or in legislation. There is, of course, constitutional reference to health, one of them being in the Directive Principles of Social Policy, about endeavouring to ensure the strength and health of workers, men and women, and the tender age of children. So there's very little reference to health, obviously, in the Constitution, and nothing specifically on health care. As Aoife mentioned, it has been minimalised in that it's only in the Directive Principles of Social Policy, and while that it's not cognisable for the courts and it's for the general guidance of the Oireachtas, I think we can safely say that the Oireachtas is not looking to the Directive Principles of Social Policy, despite the fact that a number of other jurisdictions with very, very similar provisions use it to give much more flavour to the constitutional provisions around the right to life, for example. In terms of the jurisprudence, I think it is worth noting that the right to health has been referenced as deriving from the right to life in in the Heaney decision. But going back to the case that Aoife mentioned about nursing home charges, where the constitutional right to health care was argued as part of the right to life and deriving from right to life, bodily integrity, but the court actually rejected the existence of such a right where that would create the obligation of the state to provide free health care. Now, international human rights law does not say there's a requirement to provide free health care, but I think it's probably indicative of the resistance in the court in that case and more generally the Irish Supreme Court resistance to ESC rights. Once we move out of constitutional provision, and that's mainly the focus of the presentation today, is how could we provide for the right to health or access to healthcare or to appropriate healthcare services in legislation rather than constitutionally. The right to health is not referenced in any domestic health legislation. There's no right of access to healthcare, and the presumption is absolutely on the individual, going back to the 1970 Health Act, that it's only where the payment for healthcare services would cause a person undue hardship, then that will be provided by the state. Interesting to note that the Department of Health's eligibility review published last summer, and very much then distanced by the department to say this has been superseded by government policy, but I think indicative of the thinking of the department around eligibility for healthcare was that one of the items mooted was the introduction of a legislative provision where that no one has a right to access healthcare in Ireland. And a real retrenchment back to that position, even from that presumption of the liability of the individual. So yes, we absolutely have government policy around moving towards equal access to healthcare, but I think it is important to look at perhaps some of the thinking in the permanent government per se, as opposed to our elected representatives. This is not new to any of our audience. I think most of them are familiar. I think this was just to touch on some of the sense of why Amnesty has been looking at access to healthcare, in particular economic access in recent years, in that if we consider what are the issues around healthcare in Ireland as a key component of the right to health, I'm talking very fast, sorry, then I think we have to consider that most people would see economic access to healthcare as one of the most fundamental problems in terms of Irish healthcare. This data is actually probably the most recent verifiable data that we have, but I think we can safely say that the numbers of people that are struggling to access healthcare, either due to struggling to pay their insurance premiums or waiting longer for care, continues to grow through the economic crisis. It also goes back to that point that is mentioned by a number of speakers about how do we adequately monitor our systems of service provision to ensure that we actually are delivering on people's needs. And interestingly, the undue hardship criteria, which decides whether you're eligible for a medical card, is not necessarily tied to national poverty statistics. So you can be living in poverty or at risk of poverty and not qualify for a medical card. The figures on the increase in private health insurances, again, has gone up exponentially. And that fear that people are, if not cancelling their private health insurance, are cutting back on their cover for fear that they would have to rely entirely on public provision. That said, we do have significant new commitments from the Programme for Government last year, and a lot of the language that actually we would see in international human rights instruments around universal care, guaranteeing access, and a lot of the language of the Irish healthcare system around ending the unfair, unequal, inefficient two-tier health system. Fascinating when we were doing this research as Amnesty and you talk to international colleagues, it beggars belief in some ways that there is such a two-tier system of healthcare provision in Ireland. But what we have at least is the roadmap, if nothing else, for what healthcare provision could start to look like. That said, none of it is obviously referencing human rights. There's no reference to human rights in the health section. Colm has mentioned earlier this requirement that all public bodies take due note of equality and human rights in carrying out their functions. What does that mean for the Department of Health? What does it mean for the HSE? What does it mean for individual service providers? Fine Gael talk about access as a right, and this afternoon one of the speakers will get into that discussion in what is a right as opposed to what is a human right based on international legal obligation. Labour have talked about healthcare in terms of the right to health, and the Taoiseach on the record as healthcare being a basic human need and basic human right. The only place that actually human rights law and health is brought together in the Programme for Government is really around the Mental Health Act being measured against the Convention on the Rights of Persons with Disability. So there is some recognition in there that domestic health policy has to be referenced throughout with human rights obligations. As mentioned, the focus today is really around what's the role of law in this. And we're not saying that law is a panacea, but where can law play a role, either constitutionally or in statutory provision, in terms of delivering on human rights obligations? And if we go back to the obligations of the states, and we don't use that word obligations lightly, that one of the items that states are required to do is to take appropriate means, including the adoption of legislative measures. And legislation has a particular role to play where policy is not delivering in terms of services or in terms of people's access to rights. And again, just going back, if we reference that legislative measures requirement against the need for the state to deliver the highest attainable standard of physical and mental health. The fact that Ireland doesn't use the right to health in the delivery of its healthcare policy or service delivery has been picked up by the Committee on Economic, Social and Cultural Rights previously, and worth noting that it's now over a decade since that committee actually examined the delivery of those rights in Ireland. But what they were referencing in 1999 and again in 2002 is that the state has not incorporated the International Covenant on Economic, Social and Cultural Rights into Irish law and hasn't taken the steps to do so. So even if we didn't get to the point of constitutional incorporation, what could we do in terms of domestic legislation? When we look back, interestingly, at political measures in the last decade, we see Labour in 1999 bring forward a private member's bill to constitutionally incorporate ESCR, but we haven't seen similar measures to say we need an Economic, Social and Cultural Rights Act that would allow for the Oireachtas debate around those issues. What are the rights that we are going to provide for? The work that my team has been particularly focused on is that question of, if you have the Programme for Government commitments and you have your international human rights obligations, how could you actually embed those human rights commitments into the Programme for Government legislation? There are a number of pieces of legislation promised as part of that package of reform, including the Universal Primary Care Act and the Universal Health Insurance Act. Now, We might not see those pieces of legislation for 2 or 3 years, but there are a number of ways that that legislation could actually include legislative provision around equal access. And the point is to actually write the provision into law rather than taking the risk that the policy ultimately doesn't deliver when implemented or fails to deliver over time. So it may be the explicit incorporation of the right to health. From that, we derive out the right to access healthcare on an equal basis. The obligation on government and healthcare providers to provide equal access to necessary healthcare. There's obviously a role for government in determining what that healthcare looks like, and I think we've heard from other jurisdictions about how that process of negotiation works. A statutory individual entitlement of equal access to healthcare, or some kind of non-discrimination provision. What would be very interesting is to see how the equality legislative framework currently in Ireland would match up with some kind of healthcare provision, given that we don't have a provision around discrimination and socioeconomic status. And one of the other big pieces is what is the accountability mechanism. The Amnesty research that was referenced, the healthcare guaranteed research, was flagged a number of the problems with accountability mechanisms in terms of healthcare in Ireland. The Ombudsman is next door, so I'm sure she's all too familiar with some of the provision, some of the concerns around complaints within healthcare provision. But how do we make accountability mechanisms part and parcel of the healthcare legislation that's due to be brought forward? That's not just about how the system operates or about individual access, but some kind of combination of the two, both performance review and individual access to remedy. We're not making it up from the sky. As Colin mentioned earlier, there are answers to the questions we're asking. And if you look at where we can see legislative or constitutional provision around access to healthcare, we can do it constitutionally. Conor has mentioned South Africa. We obviously have similar provisions in India. Aoife has mentioned the Argentinian example, but if we look at a number of jurisdictions where they're either providing access to care, a guarantee of a level of protection, or are using an equality provision in their constitution in order to address access to healthcare. Once we move into the realm of legislation, there's a couple of options in terms of providing for access to care, either putting an obligation on government to provide services on an equal basis with cost to be met at a certain level, providing a provision around patient rights or the rights that I attach to individuals as a patient, as we've seen in Scandinavia, or also some of the care guarantees that in some ways are quite like the National Treatment Purchase Fund, in that if you wait a certain length of time for care, then there are remedies in terms of what you can do to try and access that care. The other interesting piece is the Vermont example, and that's probably one of the more relevant ones for Ireland. What is the foundational piece of legislation that will guide healthcare reform? In Vermont, they set out a number of principles that were not necessarily explicit human rights principles or named explicitly as human rights principles, but were based on and found their foundation in international human rights law around accessibility, around universality, around accountability, and then designing a system in line with those in line with those principles. And a very, very interesting correlation between what happened in Vermont and what's going on just now with the government's implementation group on universal health insurance is saying we have these principles, and what we currently have is the programme for government principles, and then how do we design a system that will deliver the outcomes that best match those principles, and going away and deciding, is it single payer health insurers, is it multi-payer health insurers, but the criteria are the principles that are ascribed in the legislation, and framing the health policy, health provision design around those principles. So there's lots of ways in which the legislation could actually play a key role, both in designing the system from the start and acting as a mechanism for checking on the healthcare system as it develops over the next 10, 20, 30 years. Part of what I've talked about here is why we are going after this, the legal guarantee of equal access to healthcare. Part of it is the sustainability. We obviously all have that same concern of we can have a very good policy moment and get to a certain stage in policy and we see a rollback on it because of political change. The focus on outcomes, if we establish the principles for international human rights law and the requirement to deliver best outcomes to those individuals, it's not ascribing particular policy choices, but giving government a framework for deciding the policy merits of any particular system. That idea of a foundational system that everything else has to be geared around and measured against, and against that question of accountability. How do we as individuals question the provision of access to healthcare, or how do we address the system where the system's failing? One of the big criticisms, for example, from the Dutch healthcare system, which is referenced frequently, is the number of people that are falling out with the insurance system. And it's very, very difficult to then reframe the healthcare system to address the fact that it's not working, and that there's actually systematic failures in there. So some kind of accountability mechanism, both for individuals and for system review. Not that Amnesty are obsessed by law, but given that human rights law insists on that strong role for legislation, particularly where policy is not working, most of you will be very familiar with Amnesty's campaign on mental health in the last almost decade, but particularly around that question of how do we move forward government's policy commitments. If we've had policies for going on 20 years around the need to move to community-based mental health services, and we even have it in the most recent government mental health policy, A Vision for Change, how do we actually drive that policy forward when it's stalling in terms of political reform? So if we look at how do we bring forward a statutory underpinning for A Vision for Change in order to deliver those community-based mental health services and increase the accountability for the delivery of those services. Establishing a framework for sustained improvement of mental health services over time, going back to Ignacio's point about progressive realisation, not saying that one policy is bad, but measuring the way in which policy is improving over time. Increasing the transparency and accountability in mental health expenditure. I think we're conscious that in that way we actually have a shared agenda perhaps with the Department of Finance or the Department of Public Expenditure and Reform. How do we ensure that our resources are being used effectively and are being used to deliver outcomes rather than, well, that's just what we spent last year? Clarifying the obligations on the HSE. Amnesty did research last year around a kind of broad overview of the institutional abuse reports in Ireland over a number of years, and what can we track out from that? Well, a lot of the time that we can track that lots of people have responsibilities but no one is ultimately accountable for the delivery of services. So how do we actually clarify the obligations of the HSE as opposed to the Department of Health, for example? And setting out the principles, again back to that sense of set out the principles from the start that will then deliver on the obligations. Amnesty's report Legislating for Change, which we can provide to people afterwards, talks about how we move from human rights recommendations to that statutory obligation on the HSE. Now, whatever the HSE looks like, in terms of the reform mechanisms that are currently in place, a detailed implementation plan, that roadmap for how we will deliver on government policy. Delivering community-based mental health services and reporting annually, that back to that point of monitoring. If you're not gathering the data, how do you know you're delivering on your human rights obligations? And providing for consistency between the reform programme and the service plan, so we don't see gaps between what is established government policy and has been for a long time, and then the annualised service plans that the HSE is working to, and breaking down the income and expenditure. So much of the discussion has been around the level of resources that we may put towards a particular service, but actually it's also about what you expect to get out of the allocation of expenditure in that area. And again, I feel like I'm repeating myself, setting out the guiding principles around the delivery of mental health services, but using frameworks as that roadmap for how we deliver on government policy, that it's not shouting from the sidelines, but saying these are tools that should guide the way governments, departments and individual ministers and individual servants are enabled to make choices based on their international human rights obligations. Where we don't have constitutional provision, there's still a huge role around legislation that we should be pursuing, with a view to ultimately seeing some kind of constitutional incorporation of that breadth of human rights obligations. Thank you. The chair went off.